We're going to talk this morning about some hot topics in international trade. There is no shortage of hot topics in international trade these days. It seems you can't open a newspaper, not that anyone ever actually does that anymore, but you can't look at your phone or your news feed without seeing some sort of story on tariffs or sanctions or other items related to international trade. So we're going to try to give you this morning a bit of an inventory of what we've seen in recent times that are hot topics and some things that we anticipate coming down the pipe and that are going to have an impact on clients. Given the size of our group, I certainly want to encourage everyone here to ask questions anytime. And if there are topics that we're not covering that you'd like to hear about, whether it's, I don't know, aluminum tariffs or US-China or any other topic that may not be on our list, if you'd like us to comment on them or have any questions about them, don't hesitate. We'll field anything. The only thing I won't talk about is Don Cherry and the poppies. That is a banished topic for this morning. Otherwise, anything you'd like to talk about, I'm happy to engage on. We're happy to engage on. A few introductory remarks. Canada's intensely trade dependent. What happens in the international trade field is disproportionately important to Canadian companies compared to, for example, companies in the US. And our trade is disproportionately concentrated with one country. In fact, when economists do fancy analyses of the level of concentration of a relative country's trade, Canada always comes towards the top of those kinds of rankings. It's clear everybody understands the trade with the US is incredibly important to us, and what happens there has very significant impacts on our economy and the clients of Denton's. So we're going to look today at a few topics. You have the 5 that we intend to cover in the overview there. We're going to talk about Canada's trade agenda post-election and a number of topics under there. We're going to talk about some updates on the trade controls and sanctions front. We're going to talk a little bit about Canada and Brexit and some reforms in the investment law area. And then we're also going to talk a little bit about the future of the WTO. Some of you may have seen headlines about the issues going on there, and we're going to try to decode that for you briefly. So I'm going to start, and we're going to go back and forth, Sean and me, on these topics. I'm going to start on the NAFTA 2.0, Canada USMCA, also known as the USMCA. In Mexico, they probably call it the Musk or something like that. I'm not going to call it the USMCA like some people have. I'll use the Canada-US Mexico agreement nomenclature that we typically see Canada using formally. As everybody knows, it's a newly negotiated agreement. It was signed almost a year ago when the 3 leaders met. It's what we call in the parlance a modern trade agreement. It has modern features to it that we didn't see in what we'd call first-generation trade agreements or second-generation trade agreements. So in that way, it's an enhancement, a renovation, a modernization of the NAFTA, which in the parlance we would have called a second-generation free trade agreement. The idea is that once the Canada-US-Mexico agreement comes into force, it replaces the NAFTA. Everybody's wondering what the current outlook for ratification is. I would say that I've rarely been paid to speculate more than in the context of the NAFTA negotiations over the last few years. It's been very challenging to read the tea leaves from the get-go, from the moment of Mr. Trump's selection and the triggering of the negotiations. It's been quite difficult to bet on the outcomes and to anticipate where this might go. The demands were outrageous at the beginning of the negotiations. The negotiations themselves were very hard fought. And now that we have a deal with everything going on in Washington, there's been, if you look at the barometer of chances of adoption of the USMCA, it's gone all over the map depending on current events in the U.S. I would say that right now the betting odds for ratification by the U.S. are as good as they've been. Notwithstanding the drama around impeachment, it looks like the administration, at least at a functioning level, the USTR and the Congress, that discussions have progressed well, that progress has been made. Everybody seems to be in agreement that this is a good idea and that it should get passed. So all the tea leaves are pointing towards ratification by the U.S., likely before Christmas. So for Canada, obviously, that's good news. The uncertainty around the ratification of the USMCA has been a significant risk factor that investments consider. And it will be good for our economy, for investment, for stability in business to have that done and dusted. A few words about some key elements in the Canada-US-Mexico agreement. One of the key demands of the U.S. was that they wanted to increase the regional content in automobiles, and they did get that. We've agreed to regional value content thresholds that were at 62.5% up to 75% in order for a car to qualify for the free trade benefits of the agreement. In addition to that, the vehicles have to meet a 70% North American steel and aluminum requirement. That's also a new feature. And as well, there's some new labor value content provision that will have to be met. So it's become harder for a vehicle manufactured in Canada, Mexico, or the U.S. to qualify for zero duty treatment. But for Canada, our automobile industry, our parts industry have looked at this and they consider these numbers workable and should overall not cause any major disruption. But it is a change in how automobile manufacturers, parts manufacturers are going to have to analyze their supply chains and be able to certify that they meet these higher requirements. The other thing that Canada conceded on was there were longstanding demands about market access for the U.S. in supply managed products, dairy, poultry, and egg products. There have been increased quotas for U.S. products coming into Canada in those categories. There's been increased protections for intellectual property. So, for example, for certain biologics, that's drugs that originate from biological chemistry as opposed to man-made chemistry. Those protections go from 8 to 10 years. And for copyright, we're increasing from 50 to 70 years following the life of the author. The other thing that's going to be of interest to consumers is increased de minimis de minimis thresholds for duty-free and tax-free sales, imports into Canada. So our current de minimis standard is $25. So any good that you import, say, you buy it off the Urban Outfitters website and you bring it into Canada, if it's under $25 Canadian, you don't pay duties on it. If it's above that, you do have to pay duties. So that de minimis threshold for duty purposes is going up to $150. For the de minimis threshold for the GST or HST, depending on where you are, is $40. So that means cheaper stuff from Amazon for all of us, but retailers aren't exactly thrilled. Or Canadian retailers aren't exactly thrilled. There's a new chapter on digital trade, which I don't have a lot of time to get into, but this is a feature of, like I said, modern trade agreements that we have nowadays. And some changes to the investor protection regime that existed under the NAFTA. And I'm going to ask Sean to just say a word about that. He's the guru on all things investment, so I'll pass it off to him for a sec to explain how the controversial Chapter 11 of NAFTA has been changed under the USMCA.
So this is the Chapter 11. Yep, it's on. This is the Chapter 11, which we hear about from time to time in the news, where either Canadian investors make claims to sue either the governments of the United States or Mexico, or U.S. or Mexican investors make similar claims for against those their respective governments. The significant change was really a rollback. So in a lot of what we see, there was some progression in the trade agreements. In the investment chapter, we actually saw a scaling back of investment protections and access to investment dispute resolution. When the parties, United States, Mexico, and Canada, were negotiating the TPP, the negotiators really thought that they were, when they were doing that negotiation, renegotiating the NAFTA. All three parties were there. They had an opportunity to revise the agreement. They would all be subject to it. And then obviously the U.S. administration immediately pulled out of the TPP. So they had another chance to renegotiate the investment chapter. So the principal change for Canada-U.S. is that once the NAFTA is terminated, there will no longer be any access to investment dispute resolution between Canada and the United States. So before, when you would have heard of these Chapter 11 cases in the news, most likely, that will just no longer be there as an option for Canadians either investing in the United States or U.S. investors investing into Canada. There will be a 3-year legacy protection, so 3 years after the investments, 3 years after the NAFTA has been terminated, those investments that have been made prior to the termination will have investor state protection under the NAFTA. But after that, there'll be no longer any protections that investors will be able to have direct recourse to between Canada and the United States. Between the United States and Mexico, it's a little bit more of a different situation. Certain industries will have direct access to dispute resolution. So oil and gas, power generation, telecoms, transport, and infrastructure. If you're a U.S. investor investing in Mexico in those specific regions or specific sectors, you will still have direct access based on the protections that are afforded to you under the USMCA. For everyone else, you will not have direct access to dispute resolution. You will first have to go to Mexican courts and try to make your case there. If you haven't been able to make your case there, or you feel that the Mexican courts have not treated you fairly, you will still be able to have access to international dispute resolution after a period of 30 months in the Mexican courts. So there's still a significant impediment to getting access to the international arbitration in the USMCA.
Thanks, Sean. I guess given sort of the soon-to-be non-existent investor protections under the Canada-U.S. Mexico agreement for Canadians investing into the U.S., and then the qualified ones for investments into Mexico, query whether people are going to start looking at sort of treaty shopping in their investments. Whether Canadian companies are going to think, well, we'll create a subsidiary in country X that has a better investment treaty with Mexico and make our investment into Mexico via that subsidiary, try to gain the benefits of treaties that way. So anticipating clients to at least ask those questions and start thinking about those things with respect to those to their investments in Mexico. A few words about entry into force. In Mexico, they've already ratified and adopted the legislation required to implement the agreement. In Canada, we tabled the legislation and then had the little matter of an election. But it's a foregone conclusion here that ratification legislation, implementing legislation, would pass. There is no mainstream party right now that opposes the implementation of the U.S.-Mexico, the Canada-U.S.-Mexico agreement. So I don't anticipate any difficulties at the House of Commons or obviously the Senate in adopting the legislation in Canada. Really, the issue is whether the U.S. is going to be able to get its act together, and I've already talked about that. I would also note that if this is a topic of particular interest for you for whatever reason, we have quite an extensive micro page within our website at Denton's where we've collected quite a significant amount of analysis, publications, etc., on the details of the agreement, the negotiations, how to do Canada-USMCA risk analysis, and so on. A lot of tools there. So if you're interested, please go do poke around. It's very easy to find. And if you're having trouble finding anything, please let me know. Sean's going to talk a little bit about the recent election and promises made with respect to trade and what we might expect from the new government with respect to their trade agenda.
Sure. So aside from the new NAFTA, there were a few trade-related promises made by the Liberal Party in the most recent election. Overall, we didn't hear a lot about international affairs or international trade, but if you took a more detailed look at their platform, you would find that a few promises were made. I think given the context that Canada has recently gone through of signing and closing the CETA agreement with Europe, the CPTPP agreement with the 11 countries in Asia Pacific, and then the NAFTA negotiations, which has really took all the bandwidth that they had over there at Global Affairs in the last 3 years. The promises were relatively light. So the first promise that they made was to create a commercial consular service, which would essentially connect Canadian businesses with local legal assistance in whatever country they're trading under. If you're an international trader and you're not trading to one of your subsidiaries, which is the bulk of international trade, you might run into a trade barrier, a legal impediment, and the government is essentially saying, look, we're here to support you. We can facilitate local legal counsel. On this note, I think it's a good time to plug Denton's global platform. We really do have an extensive international trade team throughout the world, and we're one of the firms that is based here in Canada that could really give you the global coverage on trade issues. Now back to regular programming. They've also agreed to create or propose to create a Canada-wide trade tribunal that will resolve cases relating to domestic trade barriers. That would be under the Canada Free Trade Agreement. We don't really have much details as to what this would occur. Presumably, given that they said they will create a tribunal, this will be separate from the Canadian International Trade Tribunal that currently exists. So something to watch for internal trade barriers to Canada. We've all probably heard about these, notably the case that went to the Supreme Court a few years ago relating to interprovincial alcohol trade.
Also known as free the beer.
Paul touched on supply management. This was obviously a key issue in the negotiations under both the CETA and the USMCA. The government has promised to protect supply management as well as it can within trade negotiations. But then after the fact, we've seen governments then compensate farmers that would be affected. So for the recent CETA and CPTPP agreement, the government has proposed a $1.75 billion compensation package to farmers that would have been affected. This would be rolled out over about 8 years for nearly 11,000 farmers. So in the first year, which will be the year coming up, they're expecting a total of about $345 million in compensation to be given out to various dairy farmers that qualify. And you can probably expect a similar package relating to the USMCA. I mean, one point on this, and we hear a lot about dairy farmers and dairy protections. There was a little bit given up within the CETA negotiations and the USMCA. Generally speaking, those were protracted concessions, i.e. they will happen over a very long period of time, usually over about 7 years. So not only will the Canadian agriculture industry have some time to adjust, they will also be continuing to grow during that period as well. So their growth combined with the compensation will hopefully make them roughly equal to the concessions that we've given up. The other promises were to increase funding to the WTO. We'll touch on the WTO a little bit later in the presentation, but this is very consistent to the line that you've heard the Liberal government constantly use of that Canada supports, generally speaking, a rules-based international system. And they've also agreed to expand the sanctions regime, specifically relating to Magnitsky sanctions. Now, these are sanctions that are imposed on specific individuals that have been deemed by the Canadian government to be gross human rights abusers. So essentially, they want to develop a framework that will take seized property in relation to the sanctions and use that to compensate the victims. It's unclear whether the current promise will solely relate to victims here in Canada or whether that will be a global compensation package. Alongside the specific trade promises that the government has made, Canada is currently still pursuing trade negotiations with various countries. The Liberal government under Mr. Trudeau has developed what they call Canada's progressive trade regime. This has been, in my opinion, sort of poorly defined for your average person and even your expert. There's not a lot of documents that really specify what this particularly means. Chrystia Freeland has given a few speeches sort of detailing what a progressive trade agreement might mean. Generally, they say this is trade that reflects Canadian values. If you want to sort of decipher or parse through what that means, that could be a long debate. But more specifically, looking at what has been proposed and what has been implemented, there's generally 5 criteria. So achieving fair gains from trade, specifically in relation to jobs and the middle class. So here you have, obviously, concerns about supply management. We've seen the dairy package that has been rolled out. You also have things like labor standards. This has been particularly an issue within the USMCA agreement, and specifically in relation to Mexican labor standards. One of the sort of contingencies of the agreement passing was Mexico adopting and implementing higher labor standards for specifically trade-related issues. But also generally speaking within Mexico. There's a specific focus on women, Indigenous peoples, youth, and small and medium enterprises. So we've seen the development and the, further creation of standards relating to small and medium enterprises within the USMCA and generally speaking within Canada's trade platform. You've also seen, obviously, a gendered-related analysis to trade that has been high up on the government's list of priorities, and as well an Indigenous chapter. So they've developed and they have a full text of an Indigenous chapter that they proposed or have proposed to put into various trade agreements, which would be Indigenous communities trading with other Indigenous communities in other countries. The likely first implementer of the Indigenous Trade Chapter will be New Zealand, who has specifically noted that they are interested in the chapter that Canada has developed. Obviously, you've seen a push for higher labor and environment standards. There's been specifically labor and environment chapters that have been included within the agreements. This is, to a certain extent, somewhat of an innovation. We used to sign trade agreements and then sign specifically environment agreements, which would be separate. Putting them within the framework of the agreement, is one, a step in the direction of recognizing that trade and environment are in fact connected, but two, when you look at a holistic interpretation of the agreement, it allows for certain environmental standards to be taken into account. Last but not least, there's additional protections for the right to regulate in the public interest. That is specifically a key issue and related to investment disputes, but as well as trade disputes overall, and greater transparency and participation for civil society in the negotiations. That is a point that, I guess, looking back at the USMCA, has not particularly been implemented by Canada or its trading partners in the negotiations themselves. So not to dwell on the point too specifically, here's just a snapshot of what we're negotiating right now. A lot of these negotiations have been quite protracted. They've been going on for a long time, but I would point out two specific negotiations. One would be the negotiations that Canada has recently entered into with Mercosur, which is a trading bloc in South America that comprises of Argentina, Brazil, Paraguay, and Uruguay. That was started last year, and specifically it was started on the heels of the EU sort of concluding their trade negotiations with the Mercosur bloc. The EU had been in a very protracted trade negotiation with the bloc. They had been negotiating for 20 years, and they closed their agreement in principle this summer. So I think Canada was looking at it and said, hey, if European countries are getting privileged access, we also want to be at the table as well. I would also note that the Pacific Alliance trade negotiations are coming along. That's Chile, Colombia, Mexico, Peru. This is interesting because Canada has a free trade agreement already with all of those countries. So Chile, Peru, and Mexico are all part of the TPP, and Canada and Colombia have a specific trade agreement already. So we already have preferential ties with all those countries. So this is seen largely as a more strategic initiative by Canada, an initiative to further increase our strategic engagement in the area. And further develop our presence for businesses, for tourism, for things like intellectual property with those countries as well. That being said, I guess we can pass it back to Paul.
Yeah, I guess just one dovetailing comment on that last slide with the trade negotiations that have been ongoing and the incredible length of time that a lot of these negotiations seem to take. That's pretty typical in our world, to have trade negotiations grind on for quite an extensive amount of time. And it takes a long time for the governments to achieve the required level of consensus within their countries and with industry and so on. There's political dimensions that evolve over the life of the negotiations. Look at the CETA negotiations, for example. Really from a standing start, they took almost a decade. And then before that, there was really a decade of groundwork being done by trade associations, by groups within civil society and industry groups within Europe and within Canada that were setting the stage, laying the ground, doing background work to prepare the EU and Canada to be properly motivated to do these negotiations. And still they took a long time. That's normal. That's typical. That's what we usually see. Contrast that to the NAFTA renegotiations, which were done at gunpoint within an incredibly accelerated time frame. That is not how we usually negotiate agreements, and it really underscores the incredibly unique dynamic that was at play in the renegotiation of the Canada-US-Mexico agreement. Anyway, all fun stuff for trade nerds like me, but I thought I'd underscore that. The next topic we wanted to talk about was sanctions and export controls. Now, for the first part, and I would say the slight majority of my career, sanctions and export controls were a pretty sleepy backwater of international trade law. It wasn't an area of great focus. It wasn't an area where there was really any meaningful enforcement going on by Canadian authorities. And not too many people paid much attention to it, except those that really needed to. Sanctions and export controls has become shockingly a sexy area of international trade law in recent years, and one that where we see much more client activity and inquiry than we ever have before. And that's not about to change. It's rather going in the opposite direction, and it's going to continue to be a significant focus of regulatory attention and impact on Canadian business. One of the important developments recently was the implementation by Canada just a couple of months ago of the Arms Trade Treaty, which is an international convention that was negotiated by multiple parties to try to bring some new rules to play in weapons trading, military equipment trading around the world. As a result of our signing on to the ATT, we had to make some amendments to our main trade control statute, the Export and Import Permits Act. So just very quickly, for those who aren't familiar with that piece of legislation, it is our main export control legislation in Canada, and it lists a number of goods in something called the Export Control List. And on that list, you'll find stuff that wouldn't be surprising: munitions, weapons, nuclear stuff, dual-use goods, and so on. And the way the Act works is essentially, thou shalt not export anything on that list except under the authority of a permit issued by Global Affairs. And if you violate that prohibition, you've committed a criminal offense, and it's very serious. So we had to amend that act to implement some of the commitments in the ATT. One of the things we did, which is really novel for Canada, is the implementation of new brokering controls. And what's brokering in the export control world? Brokering is when you arrange for the shipment of one good from third country A to third country B. So nothing may occur in terms of touching the goods within Canada, but it's arranged by a Canadian or by someone in Canada. That's brokering. The other significant change that we had to do to the Export and Import Permits Act was that in assessing whether to grant a permit to export some of the munitions and weapons and so on, the minister now is legislatively obliged to consider certain criteria related to international peace, security, and human rights. And the minister is prohibited from issuing a permit if he or she finds that there is a significant risk that the goods will be used to prosecute a violation of international humanitarian law or international human rights. That's new. We had policies around this sort of thing, and Canada has always sort of seen itself as a honest broker and decent player in the international world of security, and has tried to avoid selling arms to bad guys. But to have this mandatory criteria, mandatory prohibition on the minister to issue permits in those circumstances where a significant risk, whatever that might be, exists, is a new feature of our law. I mentioned already a little bit about brokering rules that now exist. They apply with respect to something called the goods on the brokering control list, which is also a new feature. I won't go into the details, but if it's of interest to your company or to you, please don't hesitate. I'm glad to discuss it further. The other thing in the sanctions world that also really illustrates the incredibly sort of intertwined nature of sanctions regimes in the world and their extraterritorial effect is what's going on in the U.S. with respect to the Cuba sanctions. Everybody in Canada has heard of Helms-Burton and the U.S. embargoes against Cuba. The Helms-Burton Act was enacted in '96, and it was designed to strengthen and increase sanctions that the U.S. imposes against Cuba. Within that piece of legislation, there was something called Title III, which allows U.S. nationals to sue, to bring a civil claim against anyone who traffics in what they call confiscated property, which is property that was seized from an individual, a U.S. individual, by the Cuban government at the time of the revolution. That Title III was passed as a piece of legislation in 1995, but its application was suspended. And it kept getting suspended by act of successive administrations for the last, how many years is that? 24 years. Earlier this year, the Trump administration decided not to continue that suspension and to allow Title III, that was already law, to come into force. So the impact of that since April, when that suspension stopped, has been that there have been a number of lawsuits that have been begun in the U.S. to seek very substantial damages from companies that are alleged to now be trafficking in what they call confiscated property. And some of the companies you'll recognize. Amazon, American Airlines, Booking.com, Expedia, Exxon, Hotels.com, Iberostar Hotels, Norwegian Cruise Lines, Scotia Holdings, Royal Caribbean, the list goes on. Sunwing. So far, as far as I know, not Air Canada, but who knows? These claims are, pretty intimidating for the targets because, among other things, they allow for treble damages to be awarded by the U.S. courts against the defendant. So that's an area of significant concern. In Canada, we've tried to adopt some measures that might alleviate the effect, the extraterritorial effect of these claims. We've had on the books for many years something called the Foreign Extraterritorial Measures Act. Again, for a long time, a sleepy backwater of international trade law that didn't see much activity, except in relation to some Cuba measures here and there, but there you go. Now it's taken on very significant importance because that act does a number of things. For example, it provides that Canadians can sue in Canada to recover their costs for defending Title III actions. So not only can they recover, what's been awarded, but they can recover the legal costs that they've actually incurred to defend those actions. Canadians can also petition the Attorney General of Canada to order the prohibition or restriction of the identification, disclosure, and production of records in Canada that are located in Canada or controlled by Canadians. So that might have a procedural impact on the disclosure of documents in those litigations in the U.S. And then Canadians can petition the Attorney General of Canada for an order to commence an action in Canada for the full recovery of any amount awarded against them in the U.S. under Title III. And judgments made under Title III will not be recognized or enforced by Canadian courts. So those are some pretty important protections that Canada has tried to impose as a practical matter in that, a conflict of laws, rock in a hard place kind of scenario. It's going to be very interesting to see how it actually plays out in the context of some of the Canadian defendants in these actions. So Sean's going to talk briefly about some of the other sanctions that have been recently imposed by Canada and that do have some impact on Canadian businesses with activities abroad.
So on the slide, you'll see these are all sanctions that have been imposed in 2019. Sanctions, generally speaking, have now become one of the frequently used foreign policy tools by the Canadian governments vis-a-vis gross human rights abusers or regimes that Canada does not particularly support on the international scale. And largely they relate to specific events or occurrences. So in relation to Venezuela, we'll all probably recall that this spring, the United States, Canada, and several other states recognized the would-be leader, Mr. Guaido, as the rightful leader of Venezuela. This was an action against the Maduro regime that is still currently governing Venezuela, but we sanctioned several people related to the Maduro regime when we imposed those sanctions. The sanctions related to Russia and Ukraine again relate to the specific events that took place a few years ago when Russia invaded a part of Ukraine. This year, Canada sanctioned both Ukrainians who had been involved in supporting Russia, as well as further Russian individuals who are involved with those actions. Similarly, Nicaragua. If anyone has been following the politics in Central America, the long-standing president, Mr. Daniel Ortega, has run into some significant political trouble, and in response, there was a significant amount of repression of anti-government protests. There were large militias that were formed that were not formally part of the government, but they went in and occupied a significant amount of foreign-held and Nicaraguan-held land that was not supportive of the regime. In turn, Canada sanctioned several people related to the Ortega regime itself. And most recently, Canada has not taken an official action in regards to Turkey, but in regards to Turkey's most recent incursion into northern Syria. Several countries have officially sanctioned Turkey for those actions. Canada has not officially sanctioned them yet, but they have released a statement stating that they are suspending the issuance of all new export permits to Turkey, specifically those related to military and technology equipment. So if you have business relations that involve Turkey and would require an export permit, those are something specifically to take into account. And I guess, suspension of export permits was imposed October of this year. So generally speaking, we're seeing that sanctions are a fairly effective tool that can be implemented quite quickly in response to international events, and Canada has not been shy on using sanctions.
Really on that, that's an understatement to say Canada has not been shy. Canada has drunk the sanctions Kool-Aid like very few countries have. We are one of the biggest imposers of international economic sanctions out there. We firmly believe in the mechanism and we use it very extensively. We are world beaters in the world of imposing sanctions. I wanted to emphasize this area of trade controls, export controls, and sanctions for just a second and go a little bit off script. The expectations on companies with respect to trade control compliance, export controls, sanctions, and trade generally, have really evolved over the last few years. And the expectations now from banks, financiers, investors of all kinds, bondholders, joint venture partners, people involved in M&A transactions and so on, have really evolved and have gotten very high. The due diligence that's done now in the area of export transactions and international sales is quite significant. And I have had a number of experiences where issues related to trade control compliance and sanctions compliance in particular have been really tough nuggets to crack, tough nuts to crack in the context of completing M&As, and have come close, but thankfully not, close to sabotaging deals. So if you are thinking of buying a company, or if you are the target, wanting to sell yourself, making sure your affairs are in order in terms of having a demonstrably strong trade compliance regime has become of paramount importance. And what are those expectations? What is it that's expected of companies in terms of trade compliance? There's very little guidance from regulatory authorities in Canada, but there is excellent guidance out there internationally, and it's reasonable to apply, for example, regulatory trade expectations from the U.S. in the Canadian context. And what are the themes that you see in those regulatory expectations? What you call the wheel of compliance, management commitment, tone from the top on these things, very important. Internal controls, appropriate accounting procedures and logistics procedures and so on. Risk assessment, having a documented and demonstrable understanding of the trade risks that you operate in terms of the countries you're operating in, the goods that you trade in, etc. Testing, auditing, validation of your program, that there's proper external verification that what you're doing is actually well done. And then finally, training. So those are the main themes that you have to think about in the context of trade controls. And as I said, the expectations just keep going higher and higher. Sean's going to talk a little bit about Brexit. We've got, by my account, about 12 minutes to go. Again, I wanted to repeat the invitation, whether online or in person. If there's questions you'd like us to deal with before we run through the rest of our presentation, please don't hesitate. Otherwise, we'll launch into a bit of substance about Brexit and some other topics. Yep.
Before we switch off North America, can you talk a bit about the softwood lumber situation in Canada and the United States?
Oh, geez, how much time do we have? It's ongoing. We continue to have anti-dumping and countervailing duties imposed on lumber from Canada. Canadian companies are subject to differing levels of anti-dumping and countervailing duty depending on whether they're what we call a sampled company or not. So some of the bigger players have their own rates for both anti-dumping and countervailing duty. The other players are subject to all others rates, and I forget exactly what they are, but I think the subsidy rate's about 14% and something similar to that for the AD rate. So Canadian exports of softwood lumber to the U.S. continue to be, have this significant headwind going into the U.S., which has an impact on supply in the U.S. and therefore, prices in the U.S. It continues to be something that we're battling at the WTO, in NAFTA panels, through U.S. courts. There's multiple proceedings that have come through. we have had success in some of them, and the U.S. is now in the process of implementing some of the decisions that have been made, that have been said, this or that part of your procedure or of your finding needs to be adjusted. That's all being worked through, and there's a very complicated process for, where, as a result of those decisions, either anti-dumping or countervailing duties go down for reimbursement of those duties. We're helping some clients in that process, and I'll tell you, we got a major victory over a year ago on exclusion of certain of certain mills because of their circumstances as being non-subsidized. And getting the refunds has been, an incredibly slow slog. So it goes on. It continues to be a major irritant. It's not particularly in the news because it's grinding on, and there are no negotiations going on. So it's all, multiple procedures that have been brought by the various exporters that are affected. Anything else on that or anything else? All right, let's talk a little bit about Brexit.
Sure, Brexit, deal or no deal? I feel like Howie Mandel. I mean, as I'm sure we all know, the UK is now going into an election which will be held on December 12th, which most people believe will be the deciding factor on if and how the UK leaves. There has been a deal that the UK Prime Minister Boris Johnson has struck, which was slightly different from the deal that Theresa May had struck with the EU. That deal has been approved by the British Parliament, and the election will largely be an election on does the UK want to leave on these terms, or does the UK want to leave at all? I think you're seeing that political division between the various UK parties at the moment. If there is a deal, if they come out of the election and they say, yes, we want to leave and we're happy to leave on these terms, you're generally going to not see significant changes immediately vis-a-vis the EU-UK relationship. If there's not a deal, currently the UK is slated to be exiting the EU on January 31st, 2020. However, as we have seen, this can always be extended. Generally speaking, I think the EU is willing to give the time necessary for the UK to get its internal affairs sorted if it does in fact want to leave.
Can I'll just jump in, again going off script here, but some of you may have seen headlines about Canada not agreeing to a rollover of the CETA with the UK or coming to some kind of agreement with the UK in the event of Brexit. There's a pretty simple reason for that. Most of the concessions that Canada would be expecting to get in an agreement like that, the UK's already said it would give to us. They have decided that their post-Brexit tariffs were going to be essentially zero duty for anything that really matters to us in Canada, and they were extending that pretty much across the board, whether or not countries had free trade agreements with them, which is a rather peculiar way of approaching it, and a lot of trade nerds like me were scratching their heads and wondering, what's going on in the UK, and does this illustrate the fact that they really don't have a lot of trade negotiation chops, because making those kinds of concessions ahead of time was really quite peculiar and puzzling to a lot of people. And in light of that, Canada said, well, if you're going to give us free trade for our merchandise anyway, what is it that we need to negotiate? What further concessions are we going to get from you? So, sort yourself out, and then if there's a reason for us to compelling reason for us to enter into free trade negotiations as and when, then we'll see. So that was kind of the reaction of Canada.
So for Canadians, if there is a no deal, it should be, relatively speaking, status quo. We will still be able to import into the UK on a duty-free basis. If there is a deal, that puts Canada in somewhat of a different position, where eventually, within the next few years, Canada will have to either make an agreement with the UK that it will continue to benefit from CETA, or negotiate a separate free trade agreement with the UK. So that's the status quo moving forward on the Brexit front. To touch on a last couple of issues in our final minutes, investment law reform has been a very hot topic in the world of investment. Canada is continually negotiating bilateral investment treaties, largely right now with a group of African countries, which we can see up there. In relation to CETA, the investment dispute resolution mechanism, the investment court, is not yet enforced. It's one of the sole elements of CETA that currently is not in place. There's been several heated debates in the EU, which has led to 2 major court decisions from the European Court of Justice, which has now paved the pathway forward. It's removed the legal uncertainties that were there for the investment court to move forward. Now, essentially, we're just waiting for all of the EU members to individually ratify CETA, and then the investment court can move forward. I would also note that Canada is in the process of remaking its model bit. There was an initial public consultation in 2018 that was put out. They received a significant amount of submissions, and we are expecting a draft of Canada's new model investment treaty sometime soon. Canada is also extensively involved in the negotiations occurring at the UN on investment reform. This is how can we make the investment procedures, largely speaking, more palatable for both international investors and states. And would also note for the particular investment nerds that at the World Bank's ICSID, the procedural rules are going under a significant amendment process, which will hopefully be put to the ICSID Administrative Council this week. So TBD on the status of that very nerdy update.
We've just got a couple minutes to go, and we started a minute or two late, so I don't want to drag you into the break time any more than we have to. I think we had a couple of thoughts put together in case there was time and interest on the WTO, and some of you may have seen some headlines about the crisis there and whether the WTO is going to implode as a result of U.S. refusal to name members to the appellate body. That's pretty interesting for people inside baseball. We had a few thoughts on that. If you're interested in that, please come see us at the break, and we'll give you our thoughts on it and where we see it at present. But I thought I'd just give a few closing remarks and then release you to the break. It's been an incredibly lively time in the world of international trade law. I've been at this game for a while, and I've never seen a period like this, primarily resulting from the actions of the U.S. administration, which have been, shockingly surprising on the trade front. No one 5 years ago would have anticipated the kind of things that we've seen. And it's had a massive impact on Canada. I said at the beginning, Canada is incredibly reliant on trade. If you add up the value of our merchandise two-way trade and our services two-way trade, that number equals to 66% of our GDP. So when you think of it that way, it's huge. We have to get trade right. Our companies have to get trade right. It's existential for our country. So it's not surprising that trade issues are so topical in Canada and so top of mind in the business and other press. Syria, Russia, international geopolitical events, they're going to continue to occur. Turkey, most recently. And we're going to continue to see the world of sanctions become even more important with more targeted people, more targeted individuals and countries and entities. with our outreach in the world, with Canada's growing trade diversification, we're going to see that become an ever more important compliance issue for Canadians. And you know, we're anticipating continued issues for our clients who are doing transactions, who are doing deals, who are trying to sell abroad more and more. And you know, the thing about trade compliance is that it's inherently international. You're always talking about at least two countries. The ability to work with colleagues around the world, frankly, for me, has been one of the most engaging things about working here at Denton's. I have the privilege of working virtually every day with colleagues in Washington and Brussels, elsewhere in the world, on these issues, trying to help clients navigate this hornet's nest of sometimes conflicting laws in the international trade sphere. And we hope that we can assist you in your various endeavors, and that you'll have nothing but good luck and great successes and fully compliant transactions going forward.